yesterday, my lord, in the judgment by my lord Justice Gowahati has accepted that condition that the NIS student has to be verified in terms of the Supreme Court. We have withheld those, we have not rejected their appointment. And that appointment will be issued, my lord, subject to the verification. There was never a submission made also. Last occasion, what was happened, that they were supposed to, the order of the court was very specific. All the petitioners ought to have been issued the appointment letter. They have again not done it. And Lordship was very clear on that. If you fail to issue the appointment letters to all the petitioners, then personal experience will follow. They have not done it. Because Lordship will see those. Subsequent interpretation of NIS does not come. All the petitioners, or the last order was very specific. Petitioners. Now they are coming and interpreting in NIS. This Lordship will kindly have this. The select list. One of the select lists I have given. The status of the selected candidates are shown as selected, while they show in remarks withheld. So these cannot be accepted, Lordship. All these things, I fail to understand why all these things have been done. What is the wrong they have done, Lordship? Approaching these courts, asking for justice. Order of the court was to appoint everyone. Lordship will see latest status is selected, but in the last remarks column, somewhere in most of the cases, this is shown as withheld. In one hand they show it as selected, in other hand in the remarks they keep it as withheld. That is the reason on the last occasion Lordship has ordered all the petitioners should be given appointment. Subsequent action if you want to take something. Now Lordship, what my learned friend has submitted, all these things are not coming in. The NIS is not there, the stay has been vacated, now they are going ahead. So they could have done it, not this stay vacated, my lord. The Honorable Court has upheld the decision of verification by the state. And what the learned friend is submitting, my lord, this is not at all applicable because this is applicable regarding the advertisement of 2023, my lord. And our advertisement is of 2020, my lord. And they have appointed it, so this recent judgment doesn't apply even, my lord. Lordship, in item number 34, the Lordship take the item number 34 petition, page number 37. The order of the court. Page number 37. Para 13. All these things also they cannot take it. These are all well settled also. In the order itself it is given. Page 13. Sorry, Lordship. Para 13, page 37. Mr. So-and-so, if I may read it, Lordship. Page 37, para 13. Mr. So-and-so, done as standing counsel for the department, opposing the stand of the petitioners, has drawn the attention of this court to the judgment and order dated 3/21, passed by the Honorable Division Bench, in which there was a direction to make the recruitment in two phases. And in the first phase, 3025 numbers of state tax qualified candidates were to be offered appointment. He submits that pursuant to the state process of appointment, the remaining 916 vacancies have remained, and they are mainly in the category of so-and-so. The department cannot be faulted upon. He submits that the candidates would be given preference for three districts, and by following the state procedure, the vacancies in the categories in which the petitioners belong have been filled up. He accordingly submits that there may not be any cause of action in this inspection. Now, subsequently, Lordship, there are 1786. This court has also taken note of the fact that the department cannot even take the stand that the application of the present petitioners were not submitted within the prescribed date, as this court, by the interim order dated so-and-so, had allowed such participation offline by the present petitioners. Now this para is very important. Para 18. Sri Majumdar, Ranesh's counsel, has taken the point that the division bench in the judgment and order dated 3/21 had however made an observation that the recruitment is to be done in two phases, and the first phase, 3025 numbers of states that qualified were to be considered, and thereafter the remaining 916 vacancies are to be filled up by the petitioners. Though it is submitted that while making the state recruitment, the remaining vacancies are of categories in which the petitioners do not qualify, thus submission made on behalf of the department cannot be sustained for more than one reason. Since in the earlier proceeding, it has been held that there cannot be any distinction between central Ctet qualified candidates and state Ctet qualified candidates, the state observation to make appointment of 3025 state Ctet qualified candidates in the first phase was given only because of the urgency to fill up the post. The remaining part of the observation to consider the appointment of the petitioners as for the 916 numbers of vacancies cannot be made ipios by the present stand of the department that vacancies are only available in such categories. This was the stand earlier taken. Lordship, why I am pointing out this, at that time, this question of NI was not there. The same recruitment conditions and eligibility condition has to appear. Now, keeping this, publishing the select list, showing the candidates is withheld, does not arise. So they are bound to issue appointment letters to all, your Lordship, on merit. Until and unless they review. So this paragraph is very categorical, Lordship. All these things have been held. Now again they are trying to bring out some causes so that again this withheld candidates has to come before the court filing a writ petition. This is their modus operandi. This is what they do, your Lordship. They could have well ahead issued the appointment letters. They have not done it. The last order of the court was very specific, Lordship, to issue the appointment letters to all the petitioners. Further, it was mentioned in the order, last order, Lordship. If they fail to do so, then on the same day, the personal appearance will be done as to why they have not done. And one more very pertinent point, Lordship. They say they have issued the appointment letter. I'd like to point out one more very important point. Lordship will see grade number 1. This is one of the candidates whose appointment has been, they have been appointed by order of this court. Grade number 1, they say, the appointee shall join in the office of the district elementary education officer of concerned district within 7 working days. He has been asked to join in the office of the district elementary officer. Then further it is said, the place of posting will be allotted after receiving necessary approval from the finance department. Now for taking approval, Lordship, earlier also remember, 2-3 orders were passed, my learners were submitted, that they are yet to take the approval of the finance department. Now again the appointment letter says that the finance approval is yet to be taken. The petitioner will go where, your Lordship?
So what harm is going to cost the petitioner? My lord, from the date of appointment, he will be getting salary.
No, Lordship.
But that's the proposition, my lord.
Let me
Once the appointment is done, he will get salary.
Then wait.
And the petitioner cannot dictate the terms of condition of the appointment.
No, we are not dictating. They are dictating all over. We are not dictating, Lordship. I am just pointing out the thing what my learned friends submitted. That the approval of the finance was yet to be taken. Then why is appointment letter shows that approval is to be taken? What is the need of this? My learned friend on many occasions has said that finance approval is yet to be taken. Please allow us time. Now this appointment letter says you go before that time. The DU will say what? The finance approval is not yet come. Please come tomorrow. Then he will keep on stretching like that. That is what they are trying to do. He will say finance approval has not come. How can I allow you to join? Please wait. This is what. Let my father friend explain on this.
There is a
Why is that?
The condition contained that they have to submit their joining before the district. Why they have selected. Now, my lord, the posting should always upon the appointing authority to district. Now, my lord, if they join, what my friend is submitting, that when they will go to the district will not accept their joining. That's an assumption, man. That's an assumption. The appointment order is very clear that they will have to submit their joining report before the district. And the posting will be given after the finance approval is done. In fact, the last occasion when this matter was taken up, our contention was that the select list is prepared, the government approval has been sought for, and after the approval, before the approval, the SIU approval has to be taken from the finance. Now, as because your lordship directed us, for compliance, the appointment order has been issued. Now, this is not going to prejudice any of the appointments, because the moment they have joined, they will start receiving salary, irrespective the posting is given to them or not.
Lordship will kindly for a moment to see the order of 7.
Everything cannot be adjudicated in a contempt proceeding.
No,
there is a direction, my lord. We are
trying to comply with the court's order.
honorably complying with the direction. The only issue with regard to those 51 candidates, my lord, that verification was kept in abeyance because the result was not declared because of the direction of this honorable court in that judgment, in WPC number
for a moment, Lordship will kindly take 7-11-24.
3794. 3794. Now, my lord, the honorable court has yesterday passed an order, my lord, passed the judgment saying that we can proceed with the verification. And even today, my lord, will record my submission, my lord. I am saying it that as the verification has now allowed to be go on, we'll proceed with the verification and we'll issue the appointment order. Those who are on the merit list. And this verification thing, my lord, this NIS thing has come because of the Honorable Supreme Court judgment. Now, we are required to verify whether during
Where is the decision?
my lord,
Where is the decision?
my lord, the judgment passed yesterday is not uploaded yet. It's not uploaded yet. It's passed in the open court.
My lord, whatever judgment has been passed yesterday, it doesn't apply because until and unless they have reviewed the judgment which is in the question in the contempt proceeding, so they cannot go for own interpretation, my lord. They have to comply with that judgment, my lord. They cannot go for the recent judgment interpretation, my lord. That is the law, basically. Until and unless they have to review it or they have to go for appeal, my lord.
Lordship, the judgment was like to be undertaken in 2 phases. First phase and second phase. First phase they have already given. So the first phase that the candidates who has been appointed, they did not have all this qualification. Now subsequently they are trying to bring this NIS issue. So these things, the Lordship Division Bench order was very specific. Two stages you do it, first and second. The only thing that remains is that they should be given direction to appoint it. And let the matter be taken up tomorrow, Your Lordship. At least they are saying that they want to publish the appointment letters or issue the appointment letters. Let this matter be taken up tomorrow. Lordship may close it on that tomorrow. The question of giving the appointment, issuing the appointment letters to the withheld candidates, and those are very only 20 to 30. So that can be done by today evening.
And what regarding my learned pen is submitting, that verification has already been done on 20th, my lord. They have done the verification, my lord. So why they couldn't publish the
On 20th.
20th, my lord? 20 September, my lord.
The revision has already been completed. So everything is done. So now the question, when this submission has been made by my learned friend, that these are now what basis of something?
My lord,
What is the basis of something?
my lord, there is a basis. My lord, there is a notification.
This is the hospital system. After the order of this court, taking personal appearance, subsequently they publish this notice asking this set of candidates, the withheld ones, to go for verification. Covering letter is at first page. They are the cover they have issued. On the last occasion, they have given us this copy. Down below, there is a direction given for verification. So by virtue of this, our petitioners went and appeared for verification. And that is what is done. Sir, nothing. If verification is done, I have published there.
But I'll have to think. But I don't have this. The verification is done, completed, well, that is nothing.
It is nothing. Copy. So their copy they have given us on that day. Verification order to be received. Verification of the petition. What else, sir? Oh. Let my friend take instruction on this, and this matter be taken after some time, because verification has already been done and completed. Only because of this issue which was pending, they were saying that we are not issuing the appointment letter. Since the issue is now resolved, it can be well done. Let this matter be taken after some time also. He may take it up at 2 o'clock. Yes, in briefly obliged.